and we do still need to make an evidentiary record. I'm joined by my two panelists who are both administrative law judges. The three of us are equal decision makers in this process. We have reviewed the file, we've reviewed the parties' opening briefs, and we're familiar with the issues, and we're very much looking forward to today's presentation. So before we go on the record, I wanted to ask if there are any questions that either side have. So I'll start with appellants.
No, Your Honor.
No, Your Honor.
And respondent?
No.
No questions, Judge.
Okay, perfect. Thank you. Okay, so then we're ready to proceed. Let me just double check with my panel members. We're good to go. And Ms. Alonzo? Okay, perfect. Okay, so then we're going on the record. And so hello again. This is the appeal of Madjidi, OTA case number 240516297. The date today is July 14th, and the time is 1:31 p.m. This hearing is being held in Cerritos, California. I am the lead administrative law judge for today's proceeding. My name is Hans Famolaro, and I'm joined by my co-panelists, Judge Stephen Kim and Judge Asaf Kletter. As I'd mentioned earlier, we're all equal decision makers in today's process. And so now I'm going to ask the parties to please do an introduction, starting with appellants.
Farzin Madjidi.
Gary Slavitt for appellants.
Sophie Keel for Franchise Tax Board.
Nathan Hall for Respondent Franchise Tax Board.
Thank you. Okay, so we had a pre-hearing conference in this case, and we issued minutes and orders. I want to go over the issues that are going to be decided in today's appeal and to state that on the record. So the first issue is whether appellants are entitled to an adjusted basis in real property of $877,000. The second issue is whether appellants are entitled to the Internal Revenue Code Section 121 exclusion of $500,000. And the third issue is whether appellants are liable for the accuracy-related penalty. Is that correct?
The issue with respect to the adjusted basis is that's not the government has allowed some basis. This is what is in dispute of the adjusted basis, the $870,000.
I understand, and that's the amount that's stated in the notice, in the government's notice of proposed adjustment and the notice of action.
Correct.
Okay. And respondent, you agree that those are the issues?
Yes, respondent agrees those are the issues.
Thank you. Okay, so also as stated in the minutes and orders, today's proceeding is expected to last approximately 90 minutes. We have my introductory remarks, and then we're going to have appellant's presentation, which is going to be a presentation by Mr. Slavitt for approximately 10 minutes. Then we have witness testimony. I understand today, Mr. Madjidi, you're the only witness who's going to be appearing on behalf of appellants. Is that correct?
That's correct.
Okay, and your testimony is going to last 30 minutes. Respondent is going to have an opportunity to cross-examine you after you're sworn in and your testimony is provided. We're going to provide about 5 minutes for those questions. And then respondent's presentation is going to be approximately 30 minutes. Is that correct?
Yes.
Okay. And then finally, we're going to give you an opportunity, appellants, to do a rebuttal or any closing remarks after respondent's presentation. So moving on to the exhibits in this case, during the pre-hearing conference, respondent provided exhibits marked as exhibits A through V, and appellants stated that there was no objection to the introduction of these exhibits into evidence. And so these exhibits, A through V, are going to be admitted into evidence at this time. Appellants at the pre-hearing conference stated that respondent's exhibits included exhibits that appellant had provided to respondent previously, and that those documents were documents that appellants were also going to rely on to present their case here today. At the time of the pre-hearing conference, appellants had no additional exhibits. I understand that appellants may have additional exhibits that they now wish to introduce into the record. Is that correct?
Yes, Your Honor.
Okay, and so what are those exhibits?
The exhibit is additional photographs. The photographs that were submitted as Exhibit U are photographs as of the sale in 2017. During the appeals hearing with the FTB, we had gone over additional pictures that were for prior to that time. I had not recalled that, and yesterday, when my client came to my office for preparation, he had brought additional kind of a PowerPoint that had the pictures from Exhibit U. Next to them, he had older pictures that showed the condominium at previous times. And so I had forgotten during our pre-hearing and literally up until yesterday that there were additional pictures.
Okay, when did your client provide these pictures to you?
Well,
approximately?
originally when we had our appeals hearing with the FTB over a year ago.
And these pictures were not provided to the FTB
They
at that time?
were, but they were not provided to the FTB's counsel. They were provided to the FTB during the hearing. It was a virtual hearing through Zoom.
Okay, so at the protest hearing, these
Yes.
pictures were part of,
I'm gonna have to ask you to please let him finish this question before you answer, and vice versa, let him answer.
thank you for the reminder, Ms. Alonso. So I'll continue. So these, I understand then your position is that these pictures were provided during the protest hearing in this case. They were considered by respondent, but they have not been provided to respondent's counsel prior to this appeal. Is that correct?
That is correct.
Okay. And these additional exhibits, I see that they've been marked as appellant's exhibits 1 through 7. Is that correct?
The intent was, I hadn't marked them yet, the intent was 1 through 7 is the page numbers. So similar to Exhibit, similar to Exhibit U that has multiple pictures, this is a supplement to Exhibit U or an additional exhibit that's intended to be one exhibit with multiple pictures. Some of the pictures are contained in Exhibit U already.
Okay. So I understand. These pictures will collectively be marked for identification as appellant's Exhibit 1. Now, this appellant's Exhibit 1, have these pictures been provided to respondent's counsel?
During the check-in period about a half an hour ago.
Okay. And so let me ask respondents, do you have any objection to the introduction of this additional exhibit, which are these additional pictures of the condominium?
First, respondent would like to note that at least some of these pictures are brand new. I don't recognize from the audit file. For example, on page 5, the picture of the kitchen in the top right corner, as well as on page 7, each of those photos. I'm not positive were in the record, in the audit file record.
Okay, so just so that I can clarify for the record, these additional pictures, other than the picture on the top right-hand corner on page 5 of Exhibit 1, and all of the pictures contained on page 7, you do recognize these pictures and you have seen these pictures previously?
Yes.
Okay, and why were these pictures, the other pictures, other than the ones on page 7 and the one on page 5, why were these not contained in Exhibit U with the additional pictures?
At some point, there was also Exhibit U was provided to Franchise Tax Board, and during appeal, I compiled that exhibit for the record, and appellant could have provided these photos to the record at any point.
But do you recall why they weren't included with Exhibit U? I guess I still didn't understand.
My understanding of Exhibit U was it was one compiled document. So when that's what I saw in either the protest or the audit file, so that's kind of what I chose for the, including in the record.
Okay, I understand. Okay, so then respondent's position with respect to Exhibit 1, and I can give you a few moments if you want to confer. Would you like to confer about how you want to address Appellant's Exhibit 1, or are you ready to state your position, whether you have an objection to the introduction of this exhibit?
Judge, we'll confer just for one moment.
Okay, so we'll go off the record for just a few minutes. Are the parties ready to continue?
Yes.
Okay, we're going back on the record. Okay, so respondent, do you have an objection to the introduction of Appellant's Exhibit 1 into the record?
Respondent would like to point out that per the June 18th order, exhibits were required to be exchanged prior to June 29th, and that order stated that they may be excluded absent a showing of good cause. So respondent would like to ask appellants what their showing of good cause is.
Okay, so, and that's as to all of the pictures contained in Appellant's Exhibit 1, is that correct?
Yes.
Okay, okay, appellants, what is the reason for not, I understand that you said, Mr. Slavitt, that your client had provided you these pictures previously, you had provided it during the protest hearing, and that it was an oversight, I understand, on your part as to why the pictures were not provided to OTA 15 days prior to today's appeal. Is that your position?
That's correct, Your Honor. I will confirm that page 7 was not provided to the Franchise Tax Board at any time prior to today. Is that right?
What does what do these pictures show?
So it's really 1 through 6 are what are relevant with respect to the improvements to the condo. Page 7 it's not even, it could be excluded from the record. It was just kind of an illustration of taxpayers' prior business.
Okay,
so
and what about on page 5, the top right-hand corner picture of the kitchen? Respondent said that this is the first time that they've seen that picture.
In conferring with my client, it's his recollection that was provided. You want to make a statement as to why you believe that?
Yes, Your Honor. During the presentation, I shared screen on Zoom, and I had a PowerPoint, and I went through picture by picture saying, here is my daughter at 7 years old. This is the wall she was standing in front. Look how old is the difference at 9 years old. Here's the kitchen. See, my babies were small. Now they're grown up. And I just printed those yesterday for our conference and showed it to my attorney, and we included it.
Okay.
But I shared those on screen.
So we believe it was all part of the same PowerPoint that I had provided to the FTB, excluding page 7.
Okay. No, thank you. So regarding respondent's timeliness objection, because OTA is satisfied that these records, except for the final page, on page 7 were previously provided, I don't have a particular problem with introducing them at this time. I wanted to ask, before I do, respondent, page 7 in particular, do you have any objection to the pictures appearing on page 7 of Appellant's Exhibit 1?
No objection.
Okay. Then, for good cause, then pardon me for just a moment.
Excuse me, Judge. Thank you.
Okay, sorry. So,
This is
please,
Nathan
Mr.
Hall on behalf
yes.
of respondent. Yeah, I just wanted to point out also that with respect to these pictures, having not been in the record previously, there's been no argument or written briefing on these, with regard to these. So we'd just like to point that out as well. And as appellant's counsel is aware, and as the letter that you provide when you acknowledge the appeal states, these are separate and distinct agencies. So anything that was provided during, the audit phase, would not be automatically presumed to be a part of this appeal. So we would just point that out. If the OTA, believes there should be additional briefing with respect to these pictures, then respondent would be happy to provide that.
Okay, well, let me ask respondent, would you like additional briefing? Because we certainly would provide you that opportunity if you would like the opportunity to address these pictures in post-hearing briefing.
Yes, we would prefer that.
Okay.
Additional briefing.
Okay. So then what we're going to do is that we are going to admit Appellant's Exhibit 1 in its entirety into the record. But we are going to hold the record open, and we are going to give the parties an additional opportunity to provide briefing regarding Appellant's Exhibit 1. And so, respondent, let me ask, would 30 days be sufficient for you to respond and provide your views in writing regarding this exhibit?
Yes, 30 days is sufficient.
Okay. And then, appellants, I will provide you 30 days to respond to anything that respondent files. And so we will hold the record open in this case until the additional briefing has been provided, and then issue an order closing the record. Okay. Are there any additional exhibits from either party?
Not from appellant, Your Honor.
Not from respondent.
Okay. Thank you. Let me now move on to the presentation. But before we do, one of the things that would be helpful for OTA would be if we can have an agreement by the parties how to address the 3 properties that are referenced in the briefing in this case. There are 2 Los Angeles addresses, and there's 1 Santa Monica address. The parties refer to the Los Angeles addresses in different ways, and so that we have a clean record, I would like for all of us to agree on on a term that we would use to describe each of these properties. So, appellant, I'll let you make a suggestion and find out if respondent has any objection to that. So again, there are the 2 Los Angeles properties. One is the Goshen property, the other is a Greta Way property, and then there is the Santa Monica property. So how would you suggest that we refer to these properties?
I think that's correct. The Gretna Green property, Gretna Green, I think is the name, correct? Gretna Green property is how I've been referring to it. The Goshen property and the Santa Monica condo or the Santa Monica property.
Okay. I like the Santa Monica property. I apologize. Greta Green. So Greta Green Way, actually, I think is how it's identified in the record. I think that's a full address. So we're going to refer to the Greta Green Way property as a Greta Green Way property. The Goshen Avenue property is a Goshen Avenue property. And then the Ocean Avenue property as a Santa Monica property. Respondent, is that okay with you?
Yes, just to clarify, the Santa Monica property, the Ocean Avenue, we're calling Santa Monica property.
Yes, and you can interchangeably refer to that as, let's keep this easy, as the Ocean Avenue property as well. There's really the 2 Los Angeles properties that I want to keep distinct for the record. So we'll refer to the Los Angeles properties, again, as a Goshen Avenue property and the Greta Green Way property. Is that okay with the parties?
Yes.
Okay, so we're ready to move on to the presentation in the case. And so, appellants, as I had stated, Mr. Slavitt indicated that he wanted 10 minutes to give his presentation, and then we will go ahead and swear in the witness, Mr. Madjidi, and provide you an opportunity to testify. So we'll start with Mr. Slavitt. So proceed when you're ready.
Thank you, Your Honor. As the court has previously stated, the issues today relate to Mr. and Mrs. Madjidi's residence located at 515 Ocean Avenue, penthouse in Santa Monica, referred to as the Santa Monica property. Specifically, whether the Madjidis are entitled to the Section 121 exclusion and whether they properly claim their basis in the Santa Monica condo upon sale in 2017. On their tax returns, the Madjidis reported the sale price of $6,550,000 and a basis of $1,273,617, closing costs of $340,170, and the Section 121 exclusion of $500,000. The result is that the Madjidis reported $4,436,213 of capital gain on the sale price of the property that had a sale price of $6.55 million. With respect to the basis, what is at issue is the improvements made to the condo over a 40-year period that the Madjidis owned the property. The total amount of improvements that the Madjidis claimed was approximately $880,000. Again, that's $880,000 over a 40-year ownership of a luxury penthouse in Santa Monica. The condo is a top condominium, has panoramic views of the ocean, and is just a magnificent property, and improvements were needed, and testimony will be given as to that. The FTB did not allow any improvements, none. Perhaps we wouldn't be here today if there was some reasonableness in the government's position that there was zero improvements over a 40-year period, but here we are. Today you will hear testimony from Mr. Madjidi. Mr. Madjidi is originally from Iran. He came to the U.S. in 1976 to study. In 1977, he purchased the Santa Monica property for $375,000. In 1979, during the Iranian Revolution, his family lost everything, and his parents came to the U.S. and lived with Mr. Madjidi in the condo, in the Santa Monica property. In 1981, Mr. Madjidi was married. They had kids in 1985 and 1987. At that time, all six were living in the Santa Monica property, the Madjidis, the kids, and the parents and the grandparents. As the kids grew older, in 1994, they moved into a house they purchased on Goshen Avenue in Los Angeles, in the Brentwood area of Los Angeles. The kids later attended college locally. And in 2010, Mr. Madjidi's dad died, and Mr. and Mrs. Madjidi moved back into the Santa Monica property to look after Mr. Madjidi's mom, and frankly, to enjoy the condo and the beauty of the condo. The kids were young adults at the time and remained at the Goshen residence. In 2014, an opportunity surfaced for the Madjidis to buy a residence on Gretna Green in Los Angeles that needed work. So they sold the Goshen property and purchased the Gretna Green property. The Madjidis remained at the condo, and the adult children ultimately moved to the Gretna Green property. Mr. Madjidi had a home office in the Gretna Green property. Mr. Madjidi conducted all his personal, financial, and business matters out of his office in the Gretna Green residence. He used the Gretna Green residence on all his mail so that he could receive all his mail in one location, at his office. While the facts show that Gretna Green address was used as Mr. Madjidi's mailing address, it was not, again, where he lived. The FTB relies on the address on every piece of paper that is in the exhibits. There's no dispute that the address is on those pieces of paper, but again, it does not establish that it was his principal place of residence. Again, that address was used to receive all his mail in one central location where he conducted his business. The evidence does include a letter from the property management firm, as well as Mr. Madjidi's testimony today. Accordingly, since the Santa Monica property, was owned by the Madjidis and was used as their principal residence for at least 2 of the 5 years prior to sale, Section 121 is applicable. The Madjidis made significant improvements over the 40 years of ownership. The FTB disallowed all claimed improvements. You will hear testimony today from Mr. Madjidi regarding the improvements. Further photographs have been provided, as well as a letter from the designer that assisted the Madjidis with 2 improvement projects. It is not reasonable to conclude that in the 40-year period, there were no improvements to a luxury condominium. In fact, letters from Houghton Design identifies 2 of these improvements, one for $90,000 and one for $225,000. Further, a letter from the property management firm was provided that includes a special assessment of $38,000. While the Madjidis do not have perfect records of the improvements, it's unreasonable to conclude that there are no improvements. You will also hear testimony as to the record keeping of the documents related to the improvements and what we believe may have happened to them. Further, regarding the accuracy-related penalty, taxpayers acted reasonably and with ordinary care and prudence in the preparation of their tax return. They provided all facts and information to the tax preparer and acted reasonably in estimating the improvements based on the best available records. Therefore, the accuracy-related penalty should not apply. And that concludes my opening remarks.
Thank you, Mr. Slavitt. So before I swear in Mr. Madjidi to provide his testimony, I would like to remind appellants and Mr. Slavitt that you can either ask questions of your witness or you can have him testify in the narrative. So we're flexible, and whatever would facilitate your testimony, we're comfortable with either one. So, Mr. Madjidi, I'd like to ask you to raise your right hand. And I'm going to ask you, do you swear to tell the truth and that you will tell the truth and the whole truth, but nothing but the truth? Yes or no?
Yes.
Okay, thank you. And so you may go ahead and begin.
Yeah, and I think we will use the narrative form for quite a bit of his testimony. Mr. Madjidi, start with your background, maybe going back to 1977.
By the way, 1977, 50 years ago. So at the time we sold the condo, it was 40 plus years. In 1976, we had suffered a tragedy in the family. My older sister, was studying in the United States at BYU, and at graduation night, we lost her to a car accident. So, that left the three of us. So it was very important for my parents, who blamed themselves, to be very close to me and for us to be a family unit. So in 1976, when I was going to start college, I came to the United States. I went to Santa Monica College. We had means, and I had a portfolio in Iran, and we saw that place on Ocean Avenue, and I fell in love with it. It's the most beautiful thing.
Mr. Madjidi, I'm sorry. I don't mean to interrupt, but you're speaking just a little bit quickly, and I speak quickly too. That's why I'm aware of it. So if you could just slow down just a little bit for our hearing report, I'd appreciate it.
Thank you, Your Honor. I'm a little nervous. I'll slow down. So we bought in 1977, we bought that condominium. In 1977, condominiums were something new. Everybody thought this kid is crazy wanting to buy a property at that price without land. And you got a box. You got a concrete box, nothing inside except plumbing and everything else. You had to develop the rest of it. That was the first time where we had to fix up the condo. In 1979, there was an Iranian revolution, and we were on the wrong side. So my parents had to leave the country. We could never go back. We haven't gone back. And we lost everything we had that we hadn't brought to the United States. And family units are a little different in my culture than they are here. We were a family unit. It wasn't my money, even though it was my money. It was the family money. So my parents moved in as though, they were every part of us. And they lived there, and my father at least lived there to his death, and my mother was there until we sold the place in 2017. At the onset, I lived there. I went to school there. When I got married, our after party and everything was there until we had kids. With 2 kids in a penthouse, and we changed the floors to dampen the noise, but that wasn't sufficient. So we found a place nearby on Goshen Avenue, about 2.5 miles away, with 4 bedrooms, 4 bathrooms, place for the kids to run around on the first floor, and we moved there. We lived there till the kids were ready to go to college. The Gretna Green property I started a business with a partner that I refer to as Creation. It's a juicery, and we could afford to buy another property. In my way of upbringing, you buy property, you hold on to them, and you never sell a property. That's part of our raised reality. A customer came to Creation and complained of finances and said they had a house on Gretna Green, which was just down the street from us. And it was an excellent opportunity to buy that house. And I purchased it and financed it. And it took about a year to fix it up because it was three-quarter done and they had run out of money. We used that as an opportunity. I kept my office there. I did all of my work there. The kids stayed there, and my mom and dad and I, with my wife, consistently lived at Ocean Avenue. The property managers, Ermias, who watches everything like a hawk, everybody who comes and goes, he has provided a letter testifying that we live there and as such. I never thought I would sell that Ocean Avenue property, and I considered it one of the biggest failures of my life not to be able to keep it. My partner, equal partner at creation, defrauded me. This is in the public records. Created a sub company, moved all the money there, and I ended up having to sue. And I spent over $2 million in legal fees until I surrendered, in essence. So I ended up being forced to sell Ocean Avenue, the Santa Monica property, at very short notice to be able to have cash flow to support the litigation. That's the only reason that we sold that place. I moved back with Betty, my wife, to Gretna Green. My mom had difficulty moving, so she couldn't manage stairs. So we got an apartment for her in Westwood, flat, just like Ocean Avenue was. And I,
Okay, good. So you can keep that. When did your father pass away?
2010.
And when your father passed away, did you move back into the
No.
Tell us about that.
Yes. When my father passed away, my mother needed to be cared for. We don't move our parents into retirement homes. So we moved into Ocean Avenue. Ocean Avenue, by many, when we listed, it was called the crown jewel of Ocean Avenue for a penthouse. The Gretna Green property is large, but it's on a side street, and the best view it has is my neighbor's roof. So we moved back in. It wasn't an option for my mom to move into Gretna Green and have to navigate stairs. We couldn't get an elevator, nor would we. And that became our home. I was planning to die there.
Okay. And with respect to, you mentioned when it was purchased in 1977, there was work that had to be done. It was somewhat, I don't know if you use the word shell, but it was somewhat of a shell. If you look at Exhibit B, page 2, there's a list that has been floating around, which is a list of the improvements that appellants could recall were done to the property. With respect to, and it's a table, with respect to the build-out in 1977, is that what you're referring to when you purchased the property, that work needed to be done?
Yes.
Do you recall, I know it's been a long time, do you recall what needed to be done at that time?
Yes. Everything from carpeting to painting to kitchen equipment, refrigerator, oven. There were bathroom hardware. In essence, you bought a shell, and you had to fix it up. Window treatment.
Okay, and with respect to documentation, it's my understanding, and I want you to provide testimony on this, that there was file cabinets that were kept at the Santa Monica property with documents. Can you tell us what happened to that, or tell us a little bit of history about those file cabinets?
Got it. We had 3 sets of large filing cabinets that you would see in older places. We kept all of our records in there. When we decided to sell Ocean Avenue, everything happened really fast, and we hired a crew to come in to clean it up and to stage the property. We had steel cages, that was our storage. And we asked them to put the filing cabinets and all the other stuff and pack it into the steel cage so we could quickly put the property on the market and quickly sell it to pay legal fees. After we sold the property and we moved our personal property from there, we went to the steel cage, and the steel and those cabinets were thrown away.
Okay. And if I bring your attention to what is marked as Exhibit C, page 2, it's on the letterhead of a Houghton Design Studios. Can you tell us a little bit about Houghton Design and what this letter is about?
Houghton Hamadani, the principal owner and the architect, is a well-known architect. He has helped me remodel property at Ocean Avenue and elsewhere. He's the architect that I work with on remodels, and he helped me with 2 remodels, as he has testified in his letter to us.
And the second project in the letter, which is the second to last paragraph, goes through additional work that was going to be done in 2010 when your father passed away. At the end it says this is an estimate of the renovations. Were those renovations completed? Why is he using the word estimate?
He did not. He's an architect. He did not actually was not the contractor who did the work or the subcontractors I hired to do the work. In 2010, when we moved back, Ocean Avenue is a 3,300 square foot place right near the water. Everything rusts, everything breaks, everything leaks. So I asked him to come up with a design. He came up with a design. We implemented the design, but he did not do the financial management of it. He did not do the construction management. That's why he used the term estimate.
So for clarification, this work or work similar to this work was completed?
Absolutely.
Okay. And with respect to Exhibit K, page 7, which is a letter from, I believe, the property management, in that letter it talks about a special assessment of $38,805 in 1994. Can you tell us about that?
Yes. When the Northridge Santa Monica earthquake happened, the building, the high-rise, that Park Plaza building in which we own the penthouse, suffered significant damage. And our portion of the damage, this is exterior and building damage, reinforcing the building, reinforcing the columns, rods, everything. Our portion of it came to that $39,000.
Okay. And going back to the table in Exhibit B, page 2, number 1 was the build-out of $135,000. Do you recall number 2 of $95,000, a remodel? Do you have any specific recollection of what was done? And
Invariably, every 7-8 years, because of the direct sun, the moisture and everything, we had to change the floors. They would fade away. We had to change the curtains. We had to change the faucets. We had to change the drains. And frankly, this is a very, very nice place. Upgrade them and bring them up to whatever is the latest in home remodeling and what have you.
you recall remodel number 2, same idea, or?
A smaller one, but yes.
Okay. And item number 4 on table 1 of Exhibit B, page 2, says EQ, I imagine that's earthquake
Yes.
94. We understand there was a special assessment by the condo association, but you've also listed $275,000 approximately of improvements. Can you tell us a little bit about that?
Yes. Our building was orange tagged. There was green tag, red tag, and orange tag. So you could still live in it, but it suffered substantial damage. We are on the top floor, so we got the worst of it. We had cracks in the walls. We had a marble fireplace, 2-sided marble fireplace. The 2 columns on one side completely broke. The marble was cracked. We had a mirror bar. All of it broke down. We had damage in the kitchen. We had damage in the bedrooms, and all of that had to be repaired.
Okay, and I believe item 5 was covered in the Houghton Design letter. The second paragraph discusses improvements of $90,000, so that's similar to the $87,000 that you had included. And item number 6 references remodel 2010 of $225. That's also in the Houghton letter. Is that correct?
That's correct. That was the last one when we moved in.
Yeah.
Yes.
Okay, very good. With respect to Exhibit 1, can you tell us a little bit about this exhibit, starting with page 1? What do we see on the right side, and what do we see on the left side?
The large full-color picture on the right-hand side are the listing photos by the broker, and the pictures on the left-hand side is the few pictures that I could find over the years of gathering or parties we had, but of the same spot. So on page number 1, on the left-hand side, First, you see a piano. To the left of the piano, there is a bar. It's harder to see, but the bar is clad with the same carpet that was on the floor. That was this, that's how they did things back then. And it has a wooden top and a glass bar behind it.
And is that bar affixed to the wall?
Yes, it is.
So it's something permanent there?
Yes, it is. Yes. In the second picture, you see a different version of that. You see that the glass has changed, the mirror has changed, and the side is now clad with stone, not carpet. In the listing photo, you see actually two additional rendition. I didn't have one in between. You would see the bar now has customized mirrors. There is granite, granite frame all the way around the upper portion of the bar. The bar top is also green granite, matching, that rolls around the bottom, and inside the bottom there is stone also.
Taking a look at Exhibit 1, page 2, what do we see?
So every few years with the sun, we had to change the curtains. On the lower right-hand side, you see the sales picture. And on the left-hand side, you see my various family members standing in front of the same location in our condo, and the curtains are different in each one. We went from curtains to blind to shades to curtain to blinds.
Okay, with respect to Exhibit 1, page 3, what do we see?
By the way, you also see the fireplace here, but I want to direct your attention, please, to the bar. On the upper left-hand corner, you see a different marble cladding the fireplace, and the fireplace is two-sided. On the lower picture, you see the other side of the fireplace in a subsequent picture. On the left-hand side of the lower left-hand corner, where two ladies are standing, you see a yellow marble column. That broke during the earthquake on both sides. And the only other picture I could find subsequently is the final picture of the fireplace that looks very different than the first two.
Okay, with respect to Exhibit 1, page 4, what do we see?
Okay. We change the floors every so often. Part of it is I have a large family, so there are family get-together and people dance and people below get upset. So on the right-hand side, you see a number of pictures. The first one shows my wife with the two kids, and you can see marble floor behind them. Below that, you see a young lady, my daughter, sitting down, and you see carpet in that same area. You'd see that's a different carpet in the picture above it, a lady in blue holding a baby. You see the fireplace and the carpet with the two vertical columns in another picture. There is a graduation picture below that, and behind there you see a different floor than you finally see in the two sales pictures.
Okay, with respect to Exhibit 1, page 5, what do we see?
This was to document the kitchen. So in the two left-hand pictures, you see one picture of us sitting in the kitchen, and another one, you get a peekaboo look at the kitchen, and I direct your attention to the dark cabinets. In the right-hand side, you see the same kitchen. You can see the same doors, glass doors to the left-hand side. You see the kitchen, and then in the last picture on the lower right-hand, if I can provide this digitally, you can zoom in. You see a peekaboo picture of the cabinets, and you see the matching color of the cabinets, showing that at the time of sales, these were the cabinets.
With respect to Exhibit 1, page 6, what do we see?
In this picture, in this exhibit, I tried to capture the different lighting that we had over the years that we replaced. You see chandeliers, you see scones, you see a different chandelier, and finally you see canned lights in the ceiling. What I don't have pictures of are improvement to the bathrooms, and frankly, we don't take pictures in the bathrooms.
And with respect to Exhibit 1, page 7, this is not related to the Santa Monica property. What is this picture?
In the ruling from the appeal letter that came out, it is stated that the investigator had determined that 9465 Charlieville was the headquarters of Creation Juicery, and the corporation was registered as such. 9465 Charlieville is a 600 square foot hole in the wall juice bar that I have taken a picture of. That was the first store we opened. We didn't think Creation was going to go from one hole in the wall to 15 restaurants and juice bars in 3 years. So that was the address we used. We had a factory that made bottled juice. Our paperwork was there. I conducted all of my business at home.
Just for clarification, it seemed that the FTB auditor made a conclusion that Mr. Madjidi could not be working from his home on Gretna Green because the incorporation documents for Creation somehow had a Charlieville address, and so this was just to show what Charlieville is. Okay. All right, so with respect to the Gretna Green Way property, it's your testimony today that you had an office there and conducted your personal and business out of that, your personal financial items and your business out of the Gretna Green property and used that address on all related documents. Tell us a little bit about that.
Certainly. I didn't have a home office at Santa Monica. I am at the time I was a full-time professor, so I taught a full load of courses at Pepperdine, and some of them online, some of them in person. I had the Creation business that just blew up and faster than I could ever imagine, and also we had a small property that we rented for a while. Everything I did at the Gretna Green. Ocean Avenue was where my mom lived with us. God bless her soul. She loved to go open the mail and take things out and put them anywhere. And, I just wanted one place where all of my business stuff went and nobody else touched them, opened them, or did anything with them. I needed a place that I could work, quiet place that I could, put my stuff in, have my computer there and work. And we were never planning to sell Ocean Avenue, and we were going to keep Gretna Green until we either rented it, or kids moved into it, and it was very convenient. And I also got to watch football there without anybody bothering me.
All right, so just on that line of discussion, Exhibit L and Exhibit O are bank statements, and the address is Gretna Green Way. Why is that?
I received all of my mail at Gretna Greenway.
Okay. And similar, then we would expect to see Exhibit P. There's a check made out to Park Plaza homeowners, which you obviously had to pay because you owned, but it has the Gretna Greenway. Why does the checks have Gretna Greenway on there?
Everything that I did that had to do with business finances or anything, I did from the Gretna Greenway, so the mail would come over there, and I worked there, and I kept everything there.
And even the property tax statement, Exhibit R, for the Santa Monica property, didn't go to Santa Monica.
No.
It went where?
It went to Gretna Greenway. No reason for anything to go to Santa Monica.
Okay. No further questions, Your Honor.
Okay, thank you, Mr. Madjidi, for your testimony.
Thank you, Your Honor.
Respondent, would you like to cross-examine Mr. Madjidi? Do you have any questions for him?
Yes, I have one clarification question on Exhibit 1, page 5. You said that one of the kitchen photos was as it was sold. Were you referring to the sale that you bought it for in 1977 or in 2017?
In 2017.
And you're referring to the upper left-hand corner kitchen photo?
The lower right-hand and the upper right-hand photos are the same kitchen at the same time.
In 1977.
No, I'm sorry. The lower, I'm sorry, I'll get it together. The pictures on the left-hand side, I'm trying to judge what year, they were different years. It wasn't 1977. It wasn't 2017. I look in my 40s. We bought the place when I was in my late teens, so somewhere in the 1900s, maybe 2000.
1990s.
Yeah, 1990. Gave away my age. The two on the right-hand side are the latest pictures I could find of the kitchen.
No further questions. Thank you.
Okay, thank you. So at this time, the panel members may have questions to ask you. I'm going to go ahead and start with some of the questions that I have. One of the questions I had regarding your Exhibit 1 in these pictures, I want to just ask you about each of the pages, and if you can give us the approximate date to the best of your recollection when these pictures were taken, not the ones on the right-hand side that obviously were taken right before the property was sold, but of the other pictures that are mostly on the left-hand side.
The picture on the upper left-hand corner, I know it's on March 20th, but I don't know the year. It's Iranian New Year, and that's the ceremonial spread that we have. Judging by the age of the people in there, it's probably late 80s, early 90s.
Okay, and then going to page 2.
Sorry, just a clarification picture. The picture under the spread where they're in front of the bar, is that also the late 80s, early 90s?
No, Your Honor, that would be much earlier. Probably early 80s. This one is early 80s.
The top left, page 1, what do you believe the top left is?
Early 80s,
What about the bottom left?
early 90s.
Okay, so I'm sorry, just for clarification, the top left-hand corner, early 80s, the bottom left-hand corner, early 90s. Is that what
Yes,
you
Your Honor.
specified too? Okay. Okay, no, and thank you, Judge Kletter, for the clarification. Okay, now going to page 2. So again, all the pictures other than the most recent picture in the bottom right-hand corner, when approximately were these pictures taken?
I can tell you sequentially, and I'll do my best to pin them to a year. The upper left-hand corner, where my late mom is standing, that's probably the earliest of the pictures.
Would that be early 80s, late 70s? or-
Late 70s, early 80s. The picture below it is maybe 10 years later. I'm trying to judge by how old I think I am in that picture. The two pictures up top are 5 years apart because I can tell by my daughter, the young lady in the pictures.
And the top middle picture of your daughter, approximately what year was that?
About 25 years ago or so.
How old do you think she is in that picture?
I think she's like 9, 10.
When was she born, 1985, or is that
Yes.
So that's somewhere in the mid-90s?
Yes.
And the picture to the right of that picture?
I think
Is that
Bobby is in there, my son, and so I think 5 years.
So
4 or
probably
5.
early 90s as
Yes.
I'll stop you just for a quick second. It's an
Please.
observation that my co-panelist just made, Judge Kim, is that the center picture has a date on it. It has 1996 on it. So
Oh,
your recollection is accurate. So please go ahead and continue.
the picture in the middle of the page is at least early 2000s, maybe a little later, this one. And the last picture on the lower right-hand corner is the picture on the listing of the condominium.
Okay, thank you. So then, page 3, the two pictures on the left-hand side. When do you think those were taken?
This is where my daughter is 3 years old, so
Late 80s.
late 80s. The other one is the lady in the blue is my sister-in-law. That's her wedding. So maybe 10 years later.
So mid-90s?
Yes.
Late 90s?
Yes.
What do you think, late 90s? Say it in the microphone.
Sorry, late 90s. Yes.
Okay, and Mr. Slavitt, I would just ask you not to prompt your witness.
I understand. I realized
okay.
I was doing that.
And so, moving on to page 4, the pictures, this time they're all on the right-hand side. When do you think that these were taken?
So the one that with my graduation is 1991. The one with the lady in the blue holding a baby would be 1986, roughly, because my daughter was newly born. The one next to it with my wife and the two kids, the kids are in their 12, so late 90s. The one in the center of the page depicting my mom and I, that's very early, so early 80s.
Okay, so I just wanted to make sure I understood. I think I got 4 of the pictures. I didn't, the one of the young girl at the bottom left-hand corner, when was that taken?
So late 1990s, early 1920s,
Which
this one.
are you talking about the bottom all the way to the right or the?
To the left, the one of the girl standing
to the
by
left, no,
herself.
no, that would be, she's what, 5 or 6, so 91-ish.
And then the one at the very top right-hand corner.
The kids are early teens, so
So when I'm saying top right-hand corner, I'm sorry, I'm talking about the girl specifically who's sitting by herself.
97, 98. Oh,
Okay, thank you. And so turning to page 5, I heard you testify earlier that those two pictures, the top picture and the bottom picture, were taken approximately at the same time in the late 1990s. Is that still correct? Did I understand you correctly?
within 5 or 6 years of each other, not at the same time. 'Cause,
And the first picture was taken when? I'll ask you to clarify, please.
I'm doing my best to estimate early 90s.
Okay, thank you. And so and I understood from your testimony, the top right-hand picture is is one of the listing pictures. That's one of the more recent pictures that you had provided. Is that correct?
Yes.
Okay, it's just darker in the picture, so I think that's why I just wanted to clarify it. Okay, going to page 6, the 3 pictures that are on the left-hand side, when were each of those taken approximately?
Late 90s.
And that's for all 3 pictures?
The top 2, the one on the lower left-hand corner of the page depicting a gentleman in a white suit, that's probably late 80s,
The bottom left.
bottom left.
Okay, and the 2 top pictures, late 90s? Is that what you said?
Yes. Late 80s.
Oh, okay. And I also had a question going to page 7. I wanted to understand when the pictures here were taken of your business, the Creation Juicery that you have depicted here.
They are fairly recent. I went online and I searched on Yelp for pictures, recent pictures of the store, and I find these.
Okay, so I understood from your testimony that during the period when you moved. I think between 2000, or during the time that you bought the Gretchen Greenway property. So that period between 2010 and 2014 and 2017. Between that period, you mentioned that you had a smaller business location, and it's this location, which was I think you said about 600 square feet. But you're saying that this picture is an accurate picture of the business location that you testified about. Is that correct?
May I explain, Your Honor?
Please.
So Creation had, at the time of the settlement, 15 stores. Each store was incorporated by itself. So the store on Charlieville was incorporated by itself. The store on Abbott Kinney was incorporated by itself, et cetera. And I have it listed up. So yes, at the time, this was a business entity, 640 square foot roughly, and we had multiple other restaurants. We had 3 restaurants and 12 juice bars.
It was a retail location, right?
It was yes. It was a retail location. There was no office space. Most of it was a storefront with refrigerators and a counter to make juice. And in the back, we had a restroom and storage and refrigerators.
Okay, and for clarification, you mentioned that there are 15 separate stores. Were the other stores similarly situated, or were those different locations? Were those the configuration? Were those different?
I believe there was one larger, and the rest were about the same or smaller.
Okay, and did any of those spaces have office space?
No, Your Honor.
Thank you. I wanted to ask you to clarify about the Goshen Avenue property. You mentioned that it was sold, I believe, in 2010. Is that correct? So when did you regarding the Goshen Avenue property? Let me first ask you why. I understood your testimony to be that your family needed more space, you needed more soundproofing. This was a bigger location. And is it your testimony that you purchased the Goshen Avenue property?
Yes.
When did you purchase it?
Kids were going to school, so 91, 92.
Okay, and your testimony is that you lived in the Goshen Avenue property from 1994 to 2010. Is that correct?
I don't remember the beginning of the date, but to 2010, yes.
Okay, and did you sell that property?
Yes.
When did you sell that property?
We sold the property and bought Gretna Green.
So, okay, then that would have been in 2014 that you sold Goshen Avenue. I want to understand that I make sure that I understand this timeline. So I understood. Let me back up a little bit. So the Santa Monica property, you purchased it in 1977. It was sold in December of 2017. Your testimony and your position is that you lived in the Goshen Avenue address from 1994 to 2010. Is that correct?
I'm trying to figure out the 94. So may I refresh my recollection?
Yes. And would you like a few minutes? We can give you a few minutes.
No, just the font is very small. I have a larger one. That's correct.
Okay, so you lived in the Goshen Avenue property from 1994 until 2000. 2010. I
Yes.
apologize. Till 2010. Okay, and you're saying that you sold that property. When was that sold?
Same year. I apologize for being confused. These are we sold Goshen and we bought Gretna Green. So
Okay,
let me see if I can find a date.
Okay, and I understood from your testimony and from your briefing that you moved from the Goshen Avenue property in 2010 into the Santa Monica
That's right.
property. What were you doing with the Goshen Avenue property from 2010 until the period that you said you sold it in 2014.
Thank you. Same thing I did when we bought Gretna Green. I had an office there, and the kids had their rooms there. My kids went to Pepperdine, and it was a lot easier and cheaper to keep them at home than to pay dormitory rates there.
So you had an office, and your kids, they're adult children at this point, they're living there, and you have your office.
That's right.
At the Goshen Avenue address. But you and your wife and your mother moved back to the Santa Monica property.
That's correct.
In 2010.
That's correct.
The mother had always never left there. The mother was there. He moved back in when his father died in 2010.
My parents lived at Ocean Avenue from 1977. My dad died in 2010, and my mom moved out when we sold the property.
Okay. Who, during the period that you, when you bought the Greta Greenway property, you said that your children had been living in the Goshen Avenue property until 2014, and that's when you testified that you bought the Greta Greenway property. Is it your position then that your children moved out of the Goshen Avenue property, and where did they go?
The problem with the Ocean Avenue, Santa Monica property wasn't the space, it's 3,300 square feet. Kids would run around and make everybody upset. So we bought Goshen Avenue nearby because it was on the first floor and they could run around and do whatever they wanted to do. When they grew up, they went to school, and when they went to college, they stayed home. They stayed at Goshen Avenue. We moved back with my mom after my dad died. And I kept my office there.
Where did your children go after you sold Goshen Avenue?
They moved to Gretna Green.
Okay, and what is the size? Sorry, what is the size of the Gretna Greenway property? How many bedrooms? How many bathrooms in the approximate square footage?
Approximate square footage is about 4,300 square foot, and 4 bedrooms, 4.5 bathrooms, approximately.
Okay, I wanted to change my line of questioning a bit, and I wanted to ask you specifically about the improvements that were made and your testimony regarding the improvements. Who paid for the improvements that were made?
I did.
For all of the improvements, including the improvements going back to, I believe it was, the first description was a build-out in 1977 of $135,000. You paid for that?
The build-out, I very specifically remember I did, because we were allowed to bring money out of Iran in $500,000 bunches, and it all went for buying Ocean Avenue. My parents had money when we first came. They didn't have recurring money, so they spent out their money over the years. So originally they helped out. Some of the remodeling early on they paid for, but toward the end of their life, I was the only money maker at the family. The Gretna Green property was a once-in-a-lifetime opportunity in terms of a business transaction. This was somebody who had built a custom home, ran out of money, about 85% down, needed cash immediately. I could sell Goshen Avenue, move to the made-up part of the house, the part that was completed. So that's why we moved the kids in and went to Gretna Green.
Okay, I understand. So I just want to clarify, though, with respect to the payments for these improvements. So starting with the first one, the one in 1977, your position is that you paid for that.
Yes, Your Honor.
The second one in 1984, $95,000, who paid for that?
I'm relying on my memory, but most likely my dad. I'm going with memory, because they still had money.
And so the $60,000 listed.
The master bathroom one, yes.
Who paid for that?
Again, I'm going by memory, most likely my dad.
Okay, and then the earthquake 1994 expense of $275,000.
I think I paid most of that.
Okay, and then the remodel in 2006 of $87,000.
We may have partially paid. I honestly, so we had a bank account on Union Bank in Santa Monica on Montana at night. My dad used to walk there. It's very important in my culture to let the patriarch save face. So I would deposit money there. And, you know, my dad would write checks, and he had his own money there. But that money, that bank account always had money. So most of this came from there. Now, what portion of it was my dad, what portion of it was mine, it's been so long.
Okay.
But the goal was to make him feel like he's still, you know, head of the family, and he's still taking care of all of us.
And so just the last one, just to complete my question. So for 2010, the $225,000, same thing? Or do you, is it different?
No, that was me.
Okay. I wanted to ask you, you mentioned the design letter. You mentioned that Hooten is an architect.
Yes, Your Honor.
And that you paid contractors and subcontractors to do the work. I wanted to first ask you, how was the designer listed here, the one who signed this letter? How did he come up with these amounts, these total amounts?
Okay. So one of the when we wanted to file our tax, I needed experts to help me estimate what each of these renovation had cost. So like the $60,000 for Ocean Avenue has his and her master bathroom, fairly large. So I consulted with them and said, you know, we did this. How much does it cost to update the bathroom from this condition to that condition? You give me estimate. With the $220,000. I said, I want to do this with the kitchen. I want to remove this portion of the wall. I want to get a bigger refrigerator. We want to change the floors. We want to change that. Can you price this out for me? And his estimate was $220,000.
Okay, so these are estimates that he gave you for both of these projects, but he didn't actually do the work. Is that correct?
No, he's an architect. He's a designer.
Okay.
He doesn't contract.
Did you pay him any? Yes. I'm sorry.
My apology.
Did you pay him any amounts to do these projects?
He also was the architect for creation endeavors. So no, he would do that for me as a favor.
Okay. I also wanted to clarify your testimony regarding your files being thrown away. I believe you used that term. Can you provide a little more clarification as to what happened to your files?
Certainly. So when we came to a point when we needed money fast, so we had to sell Ocean Avenue. So we talked to the broker and we said, we need to sell this, we need to stage this. And he said, okay, I'm going to come in and I'm going to move the furniture here, but get rid of all your stuff. And by now I have creation, I have a full-time job, and I have a disaster on my hand with the trial. So we hired somebody to go clean the place up. And I said, put these things in the storage. The storage is over there is, like in the garage when you go in, there are spaces and they have like a cage. And I said, put everything in the cage, throw away everything else. And that cage is about 6 foot deep. So he said, we did that, and, hired a guy and went in there and did that and took the rest of the trash out. After we sold the building and I went back to collect our stuff from the cage, the filing cabinets were gone.
Okay, and what specifically was in those filing cabinets with respect to the appeal and the issues?
Tax returns, receipts, medical records, academic records.
Okay, but specifically, you mentioned tax returns. Anything else specific to the issue, in this case, regarding your basis in the property?
If I still had those files, I could document my expenses.
Okay, and were any permits pulled for the work that was done to the Santa Monica property?
The subcontractors would pull their own permit. I would generally manage the project. I have degrees in engineering and construction.
Okay, so there were permits that were pulled for the work that was done, is that correct?
I did not pull the permits, but yes.
Okay. I appreciate your answers. I don't have any additional questions at this time, but I'm going to ask my co-panelists if they have any questions, and I'll go ahead and start with Judge Kim.
Thank you. Mr. Madjidi, you stated that the Gretna Green property was undergoing construction. Can you explain that a little more, like when construction happened and when it was completed?
Yes, Your Honor. So Gretna Green and Goshen Avenue are very close, about a quarter of a mile away, and it is on my way home when I drive there. So I watched this house starting to be built, and it went up really nicely. It was really pretty, and then they stopped construction. And then one day I was at the store, and this lady comes in and goes, "Well, how are you guys doing? Are you interested in the property?" I go, "Where?" They go, "On Gretna." Sorry, I'm telling the story. I apologize. I'll get to the point. So the house was about 3/4 of the way, 80% done. The shell was done. A lot of the improvements inside were done. Part of the kitchen was done, but she ran out of money, and she was in default. So she offered to sell the house to us, and it was a buy of an opportunity of a lifetime for an investment. And so we bought it, and I started fixing it up little by little. I have some pictures. If it's
So you're saying that your children moved in and then you completed construction, like little by little?
Yes, Your Honor. There is a main house. There is a 930 square foot garage, and on top of the garage, there is a fully functioning one-bedroom guest house. The front of the house were facing the yard where my office was, and the bathroom and the kitchen was. They were done. The guest house was fully done.
Okay, thank you.
Yes, Your Honor.
Okay. And Judge Clutter, do you have any questions?
Yes, I have a few questions. So the Ocean Avenue property, that's a 3,300 square feet, 3-bedroom, 4.5 bathroom. Is that correct?
I'm sorry, did you just say Ocean Avenue?
Yes.
Yes, Your Honor.
So when you purchased the property in 1977, did it have, let me ask it a different way. Was the amount of bathrooms increased or the amount of bedrooms increased?
No, Your Honor.
So you mentioned that switching gears, you mentioned that the Goshen Avenue property was sold, and then you acquired the Gretna Green property. Was there a gap in time between when the children were living in the Goshen Avenue property and when they, moved to the Gretna Green property?
No, Your Honor.
And then also you mentioned that you general managed the projects, the remodels on the Ocean Avenue project. In this appeal, you reached out to the designer and also the property manager, I believe, of the Ocean Avenue property. Were you unable to reach out to or get invoices from those subcontractors who did the remodels?
I was not able to. It's 20, 30 years, hence most of those, some had passed on, some are out of the state.
I understand. I don't have any more questions. Thank you.
Thank you, Judge Clutter. Okay, so respondent, you have 30 minutes for your presentation. Are you ready to begin?
Yes.
Okay, please begin.
Good afternoon. At issue in this appeal is appellant's basis and gain from the sale of real property. Taxpayers bear the burden to substantiate capital improvements that add to a property's basis. Taxpayers also must maintain accurate books and records to support the claims on their tax returns. Here, appellant's basis in the property as reported on their 2017 tax return is not supported by sufficient evidence. It is well settled that a presumption of correctness attends respondents' determinations as to issues of fact, and the taxpayer has the burden of proving such determinations erroneous. Basis is an issue of fact which the taxpayer has the burden of proving. Here, appellants have not met that burden. In 1977, appellants purchased their Santa Monica property for $377,500 and sold it in 2017 for $6,550,000. On their 2017 tax return, appellants reported an adjusted cost basis of $1,273,617. Appellants have failed to substantiate $877,000 of expenses for claimed capital improvements. Also, appellant's representative stated that respondent allowed 0 improvements, but that's actually incorrect. Respondent has allowed additions to basis of $19,117 for painting and lighting, but the remaining $877,000 of expenses for claimed capital improvements remains unsubstantiated. In support of their position that they underwent a renovation in 2006 and 2010, appellants provided a letter from a design studio, Houghton Design. Regarding the 2006 claimed remodel, the letter states that design and consulting services were provided to appellants and the approximate cost was $90,000. First, appellants have not substantiated proof of payment of $90,000 towards a renovation. Second, the letter itself does not establish that any renovation occurred. For example, it is not clear from the letter whether the $90,000 was paid by appellants for updates or was simply an estimated cost for the updates. It is also unclear whether the $90,000 included payment for Houghton Design's consulting services. Moreover, the letter does not state that appellants followed through with the remodels after any design and consulting services were provided. Regarding the 2010 claimed remodel, the letter also asserts that Houghton Design provided an estimate for a renovation for $225,000. Again, appellants have provided no proof of payment for such renovation, and in this instance, the letter clearly refers to the $225,000 cost as an estimate. Finally, appellant testified that the design and consulting services from Houghton Design were favors to appellant. Typically, costs paid and incurred for renovations are substantiated through contracts, invoices, work permits, bank statements, canceled checks, and similar documentation. Appellants have provided none of those documents. Here, the letter from Houghton Design constitutes an unsworn statement, unsupported by actual proof that any particular expenditures were incurred and paid. In Sparkman v. Commissioner, the Internal Revenue Service disallowed a taxpayer's claimed depreciation deductions in full. The taxpayer furnished a letter from a third party in support of his depreciation losses and argued that in light of the letter, the Internal Revenue Service should apply the Cohan rule to estimate his losses. Pursuant to the Cohan rule, a reasonable estimate may be made where a taxpayer has established that he or she has incurred an expense for which a deduction may be properly claimed, but is unable to support the exact amount of the expense. The Ninth Circuit Court of Appeals in Sparkman v. Commissioner declined to apply the Cohan rule, reasoning that estimations made under the Cohan rule must be based on some reasonable evidence, and testimony alone is generally considered insufficient evidence on which to base an estimation. Similarly here, appellants have provided an unsworn statement from a third party. However, the letter is not accompanied by any underlying substantive evidence. A Cohan-type analysis first requires that the taxpayer present reliable evidence on which to base an estimation. The letter from Houghton Design in and of itself is not sufficient evidence on which to base an estimation. California taxpayers have a duty to maintain necessary information, documents, books, and records relevant to support the claims on their tax returns. And the loss of supporting records needed to substantiate a deduction generally does not relieve the taxpayer of his burden. Appellants maintain that it is difficult to locate records for over 40 years of ownership. However, difficulty in locating supporting records needed to substantiate their adjusted basis does not relieve appellants of their burden. The evidence submitted is insufficient to substantiate the improvement projects claimed by appellants on their 2017 tax return. Next, to establish they are entitled to exclude $500,000 of gain pursuant to Internal Revenue Code Section 121, appellants must show that they used the Santa Monica property as their principal residence for at least 2 years between 2013 and 2017. Excuse me. Elements that determine whether a residence is the taxpayer's principal residence include records concerning moving expenses, utility bills and patterns of usage, addresses used for mail, whether there was a homeowner exemption, and information concerning the address used in the Department of Motor Vehicle Records. In 2014, appellants purchased a second property, referred to as the Gretna Green Way property, and reported the Gretna Green Way property as their address on their 2014 through 2017 tax returns. Appellants claim that the Gretna Green Way property was merely used as a mailing address, but appellants have failed to explain why this address was also listed as the address of the residence on their tax returns starting in 2014. Appellants also furnished a letter from the Santa Monica property manager. The letter states that to the best of the manager's knowledge, appellants owned and occupied the Santa Monica property unit until it sold in 2017. However, this is again an unsworn statement. Examining all the facts and circumstances, this letter, without more, is insufficient to show that the Santa Monica property was used as the appellant's primary residence during the taxable years at issue. Finally, respondent imposes an accuracy-related penalty based on substantial understatement of income tax. The understatement of income tax is $183,141 for the 2017 tax year. The penalty is properly calculated as $36,628. Appellants have not set forth any defenses to the penalty. Accordingly, the imposition of respondent's accuracy-related penalty should be sustained. I'm happy to take any questions at this time.
Okay, let me first go ahead and we need to take a break, but I think we're pretty close to wrapping up. So I wanted to ask appellants whether you have a rebuttal to respondent's testimony, and if so, how long do you think it would take? Okay, that sounds like that might take a while. So, okay, we're going to go ahead and take a break. Okay, no, we need a break. We'll take a break. It's more than just no. So we'll go ahead and take a break at this time. So let's take a break for 5 minutes, 10 minutes, 15 minutes. 15 minutes. It is now 2:58, so we'll come back at 3:13. Thank you, and we're off the record. Okay, it looks like everybody's back, so we'll go back on the record. Ms. Alonso, are you ready? Yes, okay. So we're back on the record, and where we are is that appellants have an opportunity to ask questions, provide a brief rebuttal. I understood from you, Mr. Slavitt, that you didn't have questions of respondent, but you did have some clarifying questions for the panel. Is that correct?
I have some clarifying questions I'd like to ask Mr. Madjidi that relate to the questions that the panel asked.
Thank you for that clarification. You may proceed.
Mr. Madjidi, if you own the condo, the Santa Monica property, why did your dad pay for some of the improvements?
We are a traditional family. It's one money. You don't, like, I'm dutiful to not let my dad lose face. And where he could pay, like, it's almost like a gift. I don't know if I answered your question.
And your dad did live there until 2010?
Till he died. From the day we came here till he died.
Okay, and then with respect to the purchase of Gretna Green in 2014, first, in 2014, where were you living?
When in 2014?
During the year 2014.
Oh, dude, 2014, Goshen Avenue.
You were living
No, sorry. 2014, I lived in Ocean Avenue.
And when did you move back into Ocean Avenue?
2010, when my dad died.
And when you sold the Gretna Green in 2014, when you purchased Gretna Green in 2014, did you also sell Goshen in 2014?
One transaction. The money from one escrow funded the other escrow.
And when you purchased Gretna Green in 2014, was there work to be done on Gretna Green?
Yes. We had one room up front with a half a bathroom. So upstairs wasn't done, all the bathrooms weren't done. The kitchen wasn't fully done.
And so hypothetically, first you had stated that your daughters were able to move in there above the garage or some livable portion of the house. Is that correct?
Yes, there's a 930 square foot guest house fully equipped.
And while you were living at the Santa Monica property at that time, hypothetically, if you wanted to move in or live at the Gretna Green in 2014, would there have been any place for you to live there, habitable?
We didn't have a kitchen, bathrooms, take a shower. No.
Okay.
No.
Okay. So while the FTB would like to imply that when Goshen was sold, that somehow you were living at Goshen and you moved in to Gretna Green. However, Goshen was sold at the same time Gretna Green was purchased.
Yes.
And you didn't own them at the same time. Is that correct?
That's correct.
And it would be impossible for you to live, practically impossible. Is that true for you to live at Gretna Green in 2014?
That's correct.
Okay. No further questions.
Okay, so I'm going to ask respondent if you have any cross-examination or other questions that you would like to ask of the witness. Would you like a few minutes to confer?
Just a brief moment, Judge. Thank you.
We're ready.
Okay, you may proceed.
Just one question for appellants. You just testified that Gretna Greenway property remained uninhabitable in 2014. Did you provide respondent with any proof or substantiation that there was no kitchen or Gretna Greenway property was otherwise uninhabitable.
No.
That's all. Thank you.
Okay, thank you. And so now I'm going to ask my co-panelists if they have any additional questions of either party. So I will start with Judge Clutter.
Yes, I have just a question for the court reporter's benefit. For taxpayer, can you please spell your son's name that you mentioned in your testimony?
My son's name is Bobby. Robert, we call him Bobby.
Okay, thank you. Then I have some questions for Franchise Tax Board. First, regarding the cost basis and Franchise Tax Board, it's your position that there's no reasonable way to estimate the amount of improvements. Is that correct?
Yes, that is correct.
So I'm aware in other cases that the Franchise Tax Board uses means such as a SWIFT estimator or a cost expert. They may refer to records such as property tax records. And I'm curious why the Franchise Tax Board just says it's not possible to use it in this case.
Respondent will use SWIFT estimators when there is sufficient evidence indicating the taxpayer incurred an expense, but the precise amount of the expense cannot be determined, and that is from the Cohan rule. So estimations made under the Cohan rule must be made on some reasonable evidence, and testimony alone is generally not sufficient evidence on which to base that Cohan type estimation. So here, it's our position that appellants have not provided reasonable evidence on which to base a Cohan estimation.
So I believe that the Cohan rule refers to if a taxpayer has incurred an expense, but the amount cannot be established. So from my understanding, it looks like Franchise Tax Board at various points in time had these photographic evidence, and from the evidence, it looks like the condition of the Santa Monica property has changed. So I'm curious, are you able to estimate based on these pictures or based on other methods what the amount of expense incurred would be?
While respondent will further brief on the Exhibit 1 provided today, respondent has allowed improvements for lighting and painting, which is shown in these photos.
So I guess I'm just wondering, are you able to use, now with the pictures, are you able to use the SWIFT estimator, or are you able to refer to property tax records or other records to construct an estimate?
Judge, I think what Ms. Kuhl is saying is, to the extent that respondent has been able to make estimates that we believe are reasonable based on Cohan, we have attempted to do that in terms of the photos. Again, we're going to brief the photos and we're going to address those photos, but as far as what we've allowed and what we could possibly permit with a SWIFT estimator, we can address that. But also to your point, typically that's something that happens at audit. So if the taxpayer provides those photos or provides evidence that improvements have been made at audit, then that's where the SWIFT estimator estimation will take place. The protest is generally a review of the audit. It's an objective review of whether the audit was correct or not. At that point, we would take into account any evidence provided, but that may or may not include additional estimations for improvements.
Okay, and then just switching gears, I have one question about the briefing, and then I have one question about the personal residence exclusion. So with respect to the briefing, in the sorry, this is Franchise Tax Board's opening brief on page 3. There is a reference to a document titled Park Plaza Quick Report that Franchise Tax Board says was provided to them. I'm just wondering if you can briefly explain what that is, if you remember.
Thank you, Judge. Do you know what line that's on the opening brief?
It's on line 20 of page 3.
Respondent doesn't have that in the record. However, we can include that in additional briefing.
I'm just wondering if you can explain briefly what it is to your recollection. If you don't remember, that's fine. I'm just wondering if you know.
I don't remember at this time.
Okay. And then my other question, switching gears, is about the personal residence exclusion. So my understanding is that Franchise Tax Board provides copies of tax returns to show that appellant's personal residence changed in 2014. Is that correct?
That's correct.
So the 2014 return was filed in 2015. Is that correct?
Yes.
Okay. So my concern is Franchise Tax Board is referring to, or I guess my question is, Franchise Tax Board also points out that in 2017, appellant did not claim the homestead exemption for the Santa Monica property. The question is, where did appellant claim the homestead exemption in 2014 and 2015 and 2016? Do you happen to know?
No, we do not.
Okay. And
Judge,
then-
excuse me for interrupting. I apologize. Just as a point of clarification, respondent's position is not that we're saying the tax return, since it listed the Gretna Green, the Gretna Green property, means that proves that they lived there, but it certainly is evidence that they did not live at the Ocean Avenue property. Maybe I'm getting turned around here. I guess what I'm trying to say is the address listed on the tax return for us is circumstantial evidence, and it doesn't, prove one way or the other, but certainly it doesn't support appellant's position. The other thing I would point out, I believe the taxpayers' appellant's 2013 tax return was filed in March of 2014, whereas the Greta Green property was purchased after that return would have been filed. So that is consistent with respondent's position.
Yes, and just to clarify, my question is whether respondent looked at direct evidence to determine where the primary residence was, such as the homestead exclusion.
Understood.
So I don't have any more questions. Thank you.
Okay, thank you, Judge Kletter. And so let me ask my other co-panelist if he has any further questions. So, Judge Kim, do you have any questions?
Yeah, I just had a question for Mr. Madjidi regarding, for the Gretna Green property, when was construction completed, or when was the property ready to move in state, I guess?
You always start construction, you never end construction. So it was an ongoing process, a little bit, 11 months to a year, a little over a year.
Okay. And do you have evidence to support the ongoing construction or when it was completed? Would you be able to provide that?
I can look for things, but I wouldn't even know what the evidence would look like. So there's a construction site. It's part of our day-to-day life, and we don't document things part of your day-to-day life.
Okay, but you did say that there was like a additional unit or something that your children moved into?
Oh. So the person from whom we bought the house had built a garage and a guest house. She lived there, and she was building the main house. And then she ran out of money and had to sell the property. So when we bought the properties, the kids moved into the guest house where she used to live. I took up the front, and we started the remodeling. We were in no rush.
Okay, thank you.
Yes, Your Honor.
Okay, and so I just have one clarifying question for respondent. I understood you to say that respondent allowed a certain amount of improvements. I believe you mentioned lighting and something else. I just wanted to clarify this. In respondent's opening brief, if I could direct your attention to page 2 of the opening brief in the table that lists the various improvements that were provided by appellant to respondent. Item number 7 is remodel and staging of $19,117, and that's for redo floors, clean up paint. Is that what you were referring to as the amounts that respondent allowed?
The painting, yes. However, there was also that amount, that $19,117 in audit was allowed for lighting, which I can also clarify in the additional briefing, not floors.
Okay. No, I would appreciate that. And so, okay, with that, I don't have any further questions. I want to ask the parties, whether you have any further questions of the panel, anything that you'd like to clarify at this time before we wrap up.
Nothing further.
Okay. And from respondent?
Nothing further. Thank you, Judge.
Okay. Thank you very much for your presentations. As indicated earlier, there is going to be additional briefing in this case. And so the additional briefing, we want to expand the additional briefing a bit. So the additional briefing will cover appellant's Exhibit 1, specifically the pictures contained in appellant's Exhibit 1. In addition, we would also like for respondent to provide the Park Plaza quick report indicated on page 3 of respondent's opening brief, or to explain why that document is not available. And third, what we would also like is for respondent to specifically address whether a reasonable estimate is possible based on Exhibit 1 that was provided by appellants or any other evidence which is in the record. Is that all clear?
Yes, thank you, Judge.
Okay, and so I just want to also make sure that you have enough time to do that. So I know originally we talked about 30 days. Would you like additional time to provide additional briefing?
Yes, Judge. We would actually like to get a copy of the transcript, if that's possible, so maybe 60 days?
That would be fine. And so then appellant's 30 days seems reasonable to me for you to respond to anything that respondent provides an additional briefing. Is that enough time for you?
Yes, Your Honor.
Okay, that's great. So as I'd mentioned before, in this case, we're going to go ahead and hold the record open. The record will be held open until the acknowledgement of appellant's response to respondent's additional briefing, or the deadline for filing that response has passed. And then you will receive a written opinion by the OTA 100 days after that time, so when the record is closed. So we are holding the record open, and right now we are going off record.
Judge asked if I have any records of construction lasts.
No. Yeah, actually, that's not good. Okay. Well, Your Honor, if, is it possible to go back on the record for 30 seconds?
Tell me why.
Mr. Judge Kim asked Mr. Madjidi whether he had any documents regarding the Gretna Green construction, whether he could live there or not. And so I don't know if the court is willing to keep the record open, if he can locate those documents.
Hold on one moment. Let me consult with my co-panelists. We're still off the record right now. Okay, so Ms. Alonso, can we go back on the record? Okay, thank you. So we're back on the record because appellant has asked to go back on the record to have an opportunity to clarify a response to a question from Judge Kim. And so Judge Kim had asked about improvements or the construction that was being done to the Gretna Greenway property, and when those and when the work was being done and the cost of those improvements and expenses. And so let me ask appellant, a clarifying question. Specifically, what is it that you would like to provide an additional briefing in response to Judge Kim's question?
To the extent.
Can you turn on your microphone, please?
It is. Yes, the testimony from Mr. Madjidi was, in my understanding, is that when it was purchased in 2014, it was not habitable for many people, for him, and that his daughters lived above the garage. And it was my understanding Mr. Kim was looking for maybe substantiation with respect to the fact that most of the house was uninhabitable and that it would be practically impossible for Mr. Madjidi to live there. So to the extent Mr. Madjidi can search for documents establishing that, those are the types of documents. Maybe they're pictures. Maybe I have to discuss with my client. Maybe there's I don't know if there was a certificate of occupancy that was issued before or after. So any documents that would substantiate the testimony of Mr. Madjidi that at the time of purchase it was practically uninhabitable except for maybe above the garage.
Actually, Your Honor asked me how long it took to do the renovations and then fixing, and I was going to go look to see if I had any bills I had paid 8 months, 10 months, a year away from when we moved in. Those were the kinds of things that I was looking for.
Okay. And let me ask, respondent, would you have any objection to appellants providing additional information and documents relating to these construction costs?
Well, we would just say, to the extent that these are going to be considered by OTA, we'd like an opportunity to address those documents, whatever they may be.
Okay, but you have no objection otherwise?
No objection.
Thank you. You've made this easier for us, and we appreciate it. So what we're going to do, because now both parties have information that they want to provide to OTA for us to consider in this appeal, I'm going to ask the parties to provide simultaneous additional briefing in 60 days. So respondent will have 60 days to provide an additional brief discussing the 3 items that we previously discussed on the record, and appellants will have 60 days to provide information pertaining to the construction, the habitability of the Gretna Greenway property. Is that enough time for you, appellants?
Yes, Your Honor. Yes, Your Honor.
Okay, and then we'll give each side then 30 days to respond to the other party's additional briefing. Does that work for respondent?
Yes, Judge.
Okay, and does that work for appellant?
Yes.
Okay. And so we're going to modify what we said earlier, and we're going to hold the record open again for 60 days and then an additional 30 days, and the record will be held open until the response to each party's additional briefing is due, or if that is not provided, that's when the record will be closed. And then the written opinion will be issued by OTA 100 days after that date. Do the parties have any further questions? I'll ask respondent first.
No further questions, thank you.
Okay, an appellant?
No further questions.
Okay, so great. We're going to go off the record now, and I appreciate everybody's time. Thank you.